I'm pleased to turn the call over to your host today, Paul England. Paul, please go ahead.
Thank you, and welcome everyone to the latest of our Taylor Wetting UPC webinars. So far in our countdown to the UPC series, we've discussed the structure, competence and decision-making of the UPC, its relationship with the UPO and CJU, as well as the matter of preliminary injunctions. We've also begun to look at the rules on where cases should be lodged. However, as we move towards the potential start date of the court in 2017, new developments are occurring. Specifically, since our earlier webinar on unitary patents, the unitary patent renewal fees have been announced. As a result, this webinar is an update of Part 3 on the unitary patent, which we first presented in January last year. I'm pleased to say that I'm joined for this webinar by my colleague Philip Rektorshek in our Munich office, and I'm going to hand over to Philip now to remind us what the unitary patent is and what it does.
Thank you, Paul. The unitary patent is created by Regulation 1257 of 2012 of the European Union, in which it is described with its full formal title, a European patent with a unitary effect. Article 3.1 of this regulation states that a European patent granted with the same set of claims in respect of all the participating member states shall benefit from unitary effect in the participating member states, provided that its unitary effect has been registered in the Register for Unitary Patent Protection. In other words, a unitary patent is a form of a classical European patent that has been registered as having unitary effect in the European Patent Office after grant. The unitary patent has the effect of a single right, conferring on its proprietor and licensees the right to prevent a third party from committing the infringing acts that are set out in the UPC agreement in all the 26 participating member states. Note that the protection provided across the participating member states must be uniform. Only European patents of a classical kind that are granted for all the participating states and with all the same sets of claims can benefit from unitary status. This, as the Unitary Patent Regulation recital states, ensures the fundamental purpose of the unitary patent as a patent of uniform scope of protection across Europe. The requirement for uniform scope does, however, raise questions about what happens in member states who have still not ratified the new system when it starts. It is well known now that the unitary patent will not come into force until after the UPC has been ratified by 13 member states. However, this means that the unitary patent and UPC system can start operating without as many 12 possible participating member states. That is, those who have signed the unitary patent regulation but not ratified it. What is often overlooked is the effect this partial ratification has on the geographical scope of application of the unitary patent. Article 18.2 Unitary Patent Regulation says this: a European patent for which unitary effect is registered shall have unitary effect only in those participating member states in which the Unified Patent Court has exclusive jurisdiction with regard to European patents with unitary effect at the date of registration. The effect of this provision is that a unitary patent does not extend to protecting participants in the unitary patent regulation that have not ratified the UPC agreement at the date unitary effect is registered in the EPO register. Article 18.2 has the important practical consequence for those using the system that until all the participating member states have ratified, not all unitary patents will have the same geographical scope. Unitary patent protection will not extend to include those countries that have not ratified the UPC. as more member states ratify the UPC agreement beyond the original 13 necessary for the UPC and unitary patent to come into effect, the unitary patents registered will take on a wider scope of geographical protection accordingly. The slide illustrates a hypothetical example of how the geographical scope of unitary patents may develop over time. Note that Poland is not, at the time of writing, a contracting member state to the UPC agreement. It is therefore incapable of being protected by a unitary patent, even though Poland is a member state that signed the unitary patent regulation. There is an inherent danger in the breadth of protection provided by a unitary patent. This is that any change to the status of the patent must also take effect across all the member states as a whole, in uniformity. Here lies the greatest risk to the patentee who is registered for unitary effect, and indeed for patentees of classical European patents that are not opted out of the UPC. A successful revocation of a unitary patent in one action has effect across all the participating member states. Article 2 of the regulation makes it clear about the unitary patent that it may only be limited, transferred, or revoked or lapse in respect of all the participating member states. It also follows from Article 2 of the unitary patent regulation that limitations on a unitary patent by post-grant amendment will have equal effect across the participating member states, and so will a lapse of a patent. The assignment of a unitary patent must also be made for the entirety of the patent. This is in contrast to classical European patents, where the different national designations of the same patent may be assigned to different proprietors. Although a unitary patent must be transferred in its entirety, the regulation states that a unitary patent licensed in whole or part may be licensed in respect of the whole or part of territories of the participating member states. The implication of this provision is not only that licenses may be granted to different licensees for different participating member states, it also means that any dealings that are based on licensing, such as charging a patent, will also be possible for the whole or a part of the territories of the participating member states. However, what is not abundantly clear at the moment from the part of the regulation shown is whether such licenses can be granted for different territories within a participating member state. The best view is probably that this is allowed in the same way that is for European patents. The proprietor of a unitary patent may also file a statement with the EPO saying that it is prepared to grant a license in return for appropriate consideration. The regulation also suggests in its recitals that a statement of this kind should allow a reduction in renewal fees. Compulsory licenses of unitary patents are also possible. The regulation says that compulsory licenses for unitary patents are to be governed by the laws of the participating member states to be covered by the license respectively. This means that compulsory licenses must be justified on a country-by-country basis, according to national law. However, there seems to be no reason why it should not be possible to obtain such licenses in one set of proceedings in the UPC, in which the UPC applies the various applicable laws rather than having to seek the compulsory license country by country. But this remains to be clarified. In any case, application of compulsory license along national lines is consistent with the unitary patent as a right that may be licensed in respect of the whole or part of the territories of the participating member states. One question that has only recently been addressed is whether a unitary supplementary protection certificate will be created, which can be granted on the basis of a unitary patent or whether the existing system of national SPCs will be adapted for unitary patents. Both alternatives would require amendments to the current European legislation. But the second opinion is the less radical, with the fewer changes required. In its communication titled Upgrading the Single Market, More Opportunities for People and Business, published on 28th of October 2015, the European Commission has indicated a number of areas of intellectual property law in which it is considering changes. These include the idea of a unitary SPC to be based on the unitary patent. However, no detail of how this would work has yet been proposed. Indeed, it raises complex issues, including the nature of the marketing authorizations upon which these SPCs will be based. In particular, must they be centralized, or otherwise must national marketing authorizations be in place in every member state? What if those marketing authorizations were granted at different dates? Whatever the solution to a unitary SPC might be, the alternative of requiring patentees only to apply nationally for SPC protection on the basis of a unitary patent would not be in keeping with efficiencies and cost savings that unitary patents are intended to introduce. Both the Unitary Patent Regulation in Article 6 and UPC Agreement in Article 29 contain exhaustion of provisions. They are drafted in similar terms and applicable to unitary patents and classical European patents, respectively. These articles say that the protection of these patents do not extend to products covered by the patent after that product has been placed on the market in the Union by or with the consent of the patent proprietor, unless there are legitimate grounds for the patent proprietor to oppose further commercialization of the product. These provisions, therefore, reflect the principle of European patent exhaustion that has been confirmed by the CJEU a number of times. This doctrine applies to all European Union territories protected by a classical European patent, regardless of whether the member state in which the product protected by that patent was first placed on the market is contracted to the UPC agreement. That is, Spain and Poland, or whether it is a contracting member state that has not yet ratified. However, unitary patent protection cannot be exhausted by placing a product on the market of a member state that is not protected by a unitary patent, because the member state is not participating in the unitary patent, that is Spain, or has not ratified. I will now hand back to Paul in the London office to tell you about how unitary patents may be obtained.
Thank you very much, Philip. There is no filing and prosecution of a unitary patent as such. Instead, the applicant for a unitary patent files and prosecutes in the EPO in the normal way for a European patent, or a classical patent, as you heard Philip referring to it, and as they're sometimes now referred to avoid confusion. However, the additional step is then made of filing a request for unitary effect with the EPO. This request must be made within 1 month of the date of publication of the mention of the grant in the European Patent Bulletin. So, if unitary effect is not requested for a classical European patent within this 1 month period, the opportunity to obtain unitary patent status for that patent is lost. Although the request is made after grant, the unitary patent actually takes effect retrospectively in the participating member states to the date of publication by the EPO, the mention of the grant of the underlying European patent. This has an effect on the date at which renewal fees are payable. So, on renewal fees, as we understand the position at the moment, the EPO will also be responsible for collecting, administering and remitting renewal fees for unitary patents and for keeping a register of unitary patents. This will include legal status information such as licenses, transfers, limitation, revocation or lapse. Renewal fees for unitary patents must be paid by the proprietor to the European Patent Office. They're due in respect of the years following the date of publication of grant of the patent rather than the date at which unitary effect is entered in the register, as I just mentioned. Fees are also payable for late payment of the renewal fee, and failure to pay a fee could also result in lapse of the patent. There is a discount available under the current plan, it seems, in circumstances where the proprietor of a unitary patent has filed a statement with the EPO to say that the patent is available for licenses of right under Article 8.1. Subsequent renewal fees for the unitary patent under the current proposal would be reduced by 15%. I mentioned at the beginning that we now know what the renewal fee for the patent will be. These were adopted by a select committee of the Administrative Council of the EPO on the 24th of June 2015, following the so-called True Top 4 proposal. According to this fee model, the annual renewal fee for the unitary patent, providing protection for the 26 participating EU member states, will correspond to the combined renewal fees of the 4 EU countries in which, under the current system, classical European patents are most frequently validated by patent applicants. That is, Germany, the UK, France and the Netherlands. Unitary patent renewal fees will be less than €5,000 in the first 10 years, and the total fees for maintaining the patent over the full 20-year term will amount to just over €35,000. You can see a full table of the true top 4 renewal fees in the slide that I'm showing at the moment. Now, these amount for a fraction of the total renewal fees payable in the same 26 member states in the present system. Furthermore, due to the necessity of validation in each individual member state, additional transaction costs for translations, local patent agents, etc., accrue, adding up to considerably higher total costs. These costs have served to discourage companies from seeking patent protection throughout the whole of Europe in the past. So by adopting this fee regime, the EPO says it opted for the fee proposal which provided for the lowest level of fees practicable. It took into account the fact that an affordable level of renewal fees is crucial for ensuring the attractiveness of the unitary patent to companies, especially SMEs, and thus a critical factor of a patent's success. The resulting True Top 4 fee regime proposal is therefore intended to strike the right balance between ensuring an appropriate budget for the EPO and the aim of facilitating innovation and fostering the competitiveness of European businesses. From a purely financial perspective, the new regime will obviously be particularly attractive for applicants who currently validate their European patents in 4 or more countries. It is intended, however, to also be attractive for applicants who currently only validate in fewer than 4 countries because of the high costs involved, but who would in future be happy to get patent protection in 26 member states effectively for the price of 4. So let's move on to language of the unitary patent. Regulation number 1260/2012, the translation regulation, as I shall refer to it, is a complement to the unitary patent regulation, and it deals with essentially 2 issues of language. The first is the language of grant of unitary patents, and the second is the language of translation in cases where a unitary patent is disputed in the UPC. The language of grant is provided for in Article 3 of the translation regulation. This states that the specification of a unitary patent must be published in the language of prosecution, English, French or German, and must also include translation of the claims in the other 2 languages of the EPO. In other words, the claims must be present in all 3 of English, French and German. Furthermore, a request for the unitary effect of the European patent must be submitted in the language in which the patent was prosecuted. In addition, a translation regulation also provides for translation of a unitary patent in the event of a dispute concerning it. There are two scenarios in which translation will be required. Firstly, in the event of a dispute in general. In these circumstances, the patent proprietor must provide a translation into the language used in the proceedings of the court, if the court requests it. Secondly, in disputes where issues of alleged infringement are raised specifically. In these cases, the alleged infringer can additionally require the patent proprietor to provide a full translation of the unitary patent into an official language of the participating member state of the alleged infringer's domicile. Or alternatively, the patent must be translated into the language of the participating member state where the infringement took place, assuming this is different to the language of the proceedings under the first requirement that I mentioned. In the second scenario, the translation into the defendant's language helps to offset, to some extent, the potential disadvantage to the defendant of an action being brought in a local or regional division of a member state where the language of proceeding is unfamiliar to it. It has another significance. This is that the translation regulation provides that in a dispute concerning a claim for damages, the court will take into consideration whether the alleged infringer acted without knowing, or without reasonable grounds for knowing, that he was infringing the unitary patent before having been provided with the translation. For this purpose, the provision takes particular account of the knowledge of an, in quotes, SME, a natural person or a non-profit organisation, a university or a public research organisation, close quotes. However, it is unclear whether providing a translation to the alleged infringer without anything more is intended to automatically put them on notice and satisfy this knowledge requirement. However, the practical point is that a proprietor should provide a translation to an alleged infringer as soon as they become aware that an infringement may be taking place or about to take place, in order to protect their position on damages. Where it's necessary to translate the content of the unitary patent into other languages, it's ultimately intended that this will be done by high-quality machine translations. However, translation regulation provides for a transitional period, currently 12 years, whilst the machine translation system is set up. During this period, if the language of the proceedings before the EPO is French or German, a full translation of the European patent specification must be provided into English. Or, if the language of the proceedings is in English, a full translation into an official language of an EU member state must be provided. This translation must be filed by the patentee together with the request for unitary effect. Furthermore, for those who obtain a unitary patent whose residence or principal place of business is in an EU member state with an official language other than the three EPO languages, a system of additional reimbursement will be introduced for the costs of translating their application into the EPO language of proceedings. So that concludes our webinar for today. Thank you very much for listening. Our next webinar, Countdown to the UPC Part 7, will be on the 29th of February, and this will deal with the jurisdictional rules on revocation claims and declarations of non-infringement. It will also deal with the controversial subject of bifurcation. Please join us for that next time. Thank you very much.